Yeah, what's up, kings and queens? We're back again, and as usual, we're going to the Miwa case to see what sense can we make out of it. Now, have you ever seen someone squeeze out toothpaste from its tube? In fact, that's what babies do, right? Squeeze out the toothpaste and then trying to put it back in. This is what happened in. This is what's happening like today. Judge Ratha squeezed out the toothpaste, and then he decided, no, I have to squeeze it back in. Now it's a problem for him to squeeze back that toothpaste back to the tube where it comes from. Because when they warned him yesterday, no, we can't let the Baloyi introduce this kind of evidence. We can't. Because this evidence was not there. It's new evidence. We don't know about this. He says, no, I don't know what Baloyi is going to say. I want to hear what Baloyi is going to say. And then he proceeded to squeeze the toothpaste out of his tube. Now today and yesterday, he was trying to squeeze it back in. Now it's all over the place. The toothpaste is on his fingers, it's everywhere. It can't go back in because he has already heard what Baloyi has said. And even though he had told Baloyi that that evidence cannot be considered as legit because those guys had not made pleas yet. They had not officially made a plea, guilty or not guilty. So you can't ambush them and say, no, that's it's spontaneous, as you say. No, he decided no. Baloyi is going to introduce furthermore some more evidence trying to prove that the defense know about these transcripts. Yeah, they know about the transcripts, but the concern was what was being discussed that day, not that in those transcripts they have to look out for what the accused are now pleading or whether the accused had already pleaded or not. So the judge decided, no, I'm going to let Baloyi do this. Now, today he's having a problem. When he has to reply to these guys, to the defense, to tell them what's happening, why is Baloyi doing these processes that are not regular, it's a problem for him. He's now attacking them. They can't discuss, they discuss things behind his back, and then when it comes to court, they don't know. But even though when they are telling him, no, nobody discussed anything behind anybody's back. Munisi told him blatantly, fair and square, that no, I can't discuss anything with the state off the record because I know their models, I know how they operate. They are going to come here and start doing things that we had not discussed. Judge Ratha is saying no. He still keeps on hammering on that issue that they discussed something when he was not there. Even though they're telling him, no, this is the record that was discussed in court. Now, you have to understand that Ratha is desperately trying to help this struggling case, as Munisi had called it. The state, they are struggling. Like they are really struggling because, as Advocate Munisi, in fact, Numalo had put it, they haven't addressed, they have not addressed even a single of the arguments that they put across. What they addressed was just to say the document that like the records as put across by Stein were legit, but we know that Stein fabricated something, and they tried to put across that whatever was alleged that there was a call between Haley and accused number three. They still stay with that. Other than that, they haven't answered some of the things that accused has talked about. Even the Makaleni issue that the judge helped them with, it doesn't really address. They read the statement, right? It just says somebody had dreadlocks, but he doesn't mention his name, so we can't really say that's mentioning someone that's placing him at the scene. And now, when it comes to the cell phone data. It's funny that the state will want to use it to their benefit when it's placing the accused right around phosphorus, right? As Sibanda was outlining that the phosphorus tower and then Muleki Tower, what was picking these guys up on the day of the crime. Now, when it comes to the time, they just get around the issue of the exact time. Where were they? They just get around that issue. Did you hear him address it yesterday? He didn't. He just get it around that issue because he knows that around the time of the alleged crime, those guys were somewhere around this Joburg CBD. Now, remember what the judge Ratha said about this aspect. Judge Ratha said the phone could have been in Joburg. These guys could have still been in Phosphorus. That's the argument. So, how do we say that Baloyi has adequately addressed the 174 application by Advocate Numalo? He hasn't. Anyway, I just want to share a little clip of what transpired in court today, and then we can proceed with this little bit of analysis that I'm going to give. It's a Judge Ratha is so like today he didn't even want to listen. He didn't even. He was just he was just ready to go. He was just ready to go. And then when the judgment comes, I want to see if he was going to apply that rule that he says no, even if Baloyi doesn't apply the law correctly, he just listens, and then he'll come back with this judgment later. But let's just address the strategy of the state. The state, Judge Ratha is telling them no. We can't consider that that plea that was entered by accused number 3 that you said happened in 27 October, right, 2020. We can't entertain it because those guys hadn't officially made a plea, like, right. So Baloyi is saying no. He still continues placing some more aspect about that case on record. Like, what is this? Like, even when Numalo is objecting, Siram Sipili objecting and say, no, what is the basis of this? Like, is this an application for the state to reopen the case? Munis reiterated that if the state was to open its case, it's fine, they are allowed to, but not the way they're trying to ambush the defense by just coming up with new evidence. Even when the judge is telling them that no, we can't consider this evidence, they still want to consider it as something that they can rely upon. This just shows how flimsy and thin the state's case is. The way they're desperate in grasping, that they're just grasping at straws. Nothing really is, nothing says coherence with that case, nothing. Because if we are going to talk about the cause, you want to use the cause data when it places the accused around phosphorus during the day when you're talking about the tower. But now, when it's the time of the crime, you didn't even place it during your argument, the time of the crime. What Pinky Tillingham,'s records are saying, you didn't even place it. You just placed what you feel like will cover your basis. Let's listen to a little bit of that, and then I'll go back to my blah blah, and then we'll close.
The issues in this application are specifically defined. There's been an application by accused number 4 that on the basis of the fact that the state has not been able to establish a prima facie case against him on all the counts, he requested the court that he should therefore be discharged at the close of the state's case. The state's response, the manner in which they've responded, that is the issue that needs to be determined at this point in time. Now the state stands up, and it is struggling. It's very struggling. He stands up and say, no, but there's a Makaleni issue. There's the record of the transcript, my lord. What do those submissions have to do with the application that is so circumscribed, that is so specific? And I've indicated on Tuesday, my lord, that the state, if it feels like there is something that they have missed in the presentation of their evidence, which I would refer to as struggling, they would still have the opportunity. There is nothing wrong in terms of the procedure for them to stand up and say, my lord, we acknowledge the fact that we had already closed our case.
Atera is the IT painkiller. Remote monitoring and management, remote access, help desk and ticketing, smart.
But there is information that we feel, in our view, that would be the state saying that we can use at the end of the state, at the end of the close of the case, to make an argument that will supplement our application for a conviction. Then the court will have to make a decision on whether or not it grants them that leverage or that allowance or that indulgence. But not now, my lord. Because if I were to stand up and start to address the issues that the state is now raising, this procedure will be very precarious. It will be unheard of in any civilized legal system, particularly in a system that is codified. And ours in South Africa is codified in terms of this Criminal Procedure Act number 51 of 1977. Such procedure is not allowed, my lord, particularly when there's an application in terms of section 174. This section must be dealt with and be finalized. Then the state, as I've said, if they feel there is something that they need to add into their struggling evidence, then they can stand up and say, no, we also want to add this another struggling point in our struggling evidence through an application. The state does not even apply now. It simply says, we also want to add this, we also want to add this into the record. What is the purpose of this sitting, my lord? Is it to introduce new evidence or to make a determination on whether or not accused number 4 has been able to bring to the court an argument which in the mind of the court says that it should be discharged, or the state which in the mind of the court says accused has not been able to discharge the honors in terms of section 174. Those are the issues at this point in time, my lord. Otherwise, the procedure that is being followed here, it's fiasco does not even begin to explain it, my lord. It's unheard of.
Yeah, fine. I've heard you. You see, the problem with you and your colleague arguing, you discuss.
I just want you to keep in mind what just Advocate Munisi just said, right? Just keep in mind what he just said. It's very important things that he just raised. And a lengthy address, right, at that. This is pertinent to the rights of the accused. Just listen to what now the judge is going to say. Tell me if he's answering what Munisi is saying, procedure, the flawed procedure. If he's answering that, tell me if he's answering that, or he's just decided, no, I'm going to thwart his mind. I'm just going to talk about something else. Talking about the agreement that they made when he's not there. And there's no agreement that they made that he's not there. Just listen.
Those things in my absence. And then you want me to solve them. You see, he says, you approached him. I wasn't there. No. And you complained about A, B, C, D, E, F, G. No. And now he says he's rectifying what you complained about.
I wasn't there. He listens. This is the judge that says, I listen. Are you telling me that he's not aware? He's going to be aware now when Baloyi make him realize, no, you are wrong. This is the record that was raised that time, blah blah blah, when we wanted to know about that box back proceeding court day, like, but he's just misleading them. He's going around the bushes in circles, other than instead of just addressing the point. All right, it's a problem. I don't know, and he's doing it so blatantly. Doesn't care no more. Judge Ratha doesn't care anymore. He's just showing us that he's for the state. He's the one who brought out this Macaroni thing. Now the state has applied for including Macaroni's hearsay evidence. Now he is the one who allowed Baloyi to introduce this evidence from Boxback. Now he's trying to kick it down. Baloyi is adding more things on it. He has now egg on his face. He has a problem. He's like handling a hot potato because he doesn't know what to do. Just listen.
About. Am I correct, sir?
This actually, it happened in court on Monday, as he says. That's what they said.
Now I'm
that-
being blamed for not knowing the procedure.
Yes.
No, my lord. I am not saying the court does not know the procedure. But what I'm saying is the procedure that is being followed here is unheard of. That cannot be equated to mean that the court does not know the procedure, my lord. Now, the issue is, my lord, there are issues which have been raised here. And the procedure at which we are now, which is an application in terms of section 174, does not allow parties who have not made an application in terms of that section to respond to the issues which the court needs to determine. Accused number 1 and accused number 3, accused number 5 and accused number 2 are not party to these applications. And yet there is evidence which in their mind seems to be evidence that is being introduced through the back door, my lord. Would we then be afforded the opportunity to respond? And the court said on Monday, yes, you will then respond. But state proceeds, still continues to introduce new evidence.
Okay, so are we
through the back door, my lord. Well, I don't know if this procedure, if the
Like it's not even caring to address what Minister is saying. Now you have to just pick up what happened today again. He is trying to push Baloyi towards to the conspiracy, because I think there's something that is going to rely upon, some case that is going to rely upon, that makes sure that accused number 4 doesn't get free because of conspiracy. Because he's going to say no, Baloyi is saying that he's charging these guys with conspiracy. Isn't that so? And then he quotes the wrong law. They found out that it's on sentencing and all that. And then he changes it. He tried to come up with another authority which doesn't really agree with him. When Ramsepeli brings his authority, and even Numalo says, try to chip in and say, no, this evidence is irrelevant. I just want you to consider scrapping it out, like just wipe it out, wipe it off the record. He says he will. And like he's not even promising to wipe it off. He's just telling Numalo, if you want to tell me to wipe it off, tell me to wipe it off. And then Numalo says so. He decides to go. But watch the fact that now he's pushing Baloyi towards the fact that Baloyi has to catch these guys with conspiracy. And if I had it properly, conspiracy and common cause, I don't think they are one and the same thing, and I don't think that's what Baloyi used common cause, like something like that. Anyway, guys, let's listen to the judge. He's back to his normal self. Don't be surprised. Those who know him know that this is what they do. Let's listen.
court really affirms this procedure, I'm in the hands of the
No,
court.
don't talk
But
about
it's
the procedure, because I'm telling you what you do in my absence.
no, but my lord, there was no agreement. There's no
I don't
agreement
know.
that we've
But you spoke to him.
about what, my lord? We spoke to him
Okay,
about what?
fine. That's it. I
I
hope-
never speak to the state, my lord, because I know
Now, when he's confronted to address what he says they agreed upon, he runs away because now it doesn't come to his mind immediately what the agreement that he's alleging doesn't know about it, but he just decided to talk about it. Man, now when he's confronted with that agreement, which agreement are you talking about? He can't voice it out. He wants to proceed. He wants to move on to something else. This is what he does all the time.
The way in which they operate, everything that I do, I make it a point that it is done on record. I know the way in which they operate.
The course that MIT is offering with NASA, Boeing, and other partners will bring together.
You are right, Mr. Informative Channel.
As you pointed out, that is, we're responding to their complaint on Monday that they were not made aware of the proceedings. But, my lord, we've made submissions. We have summarized the evidence. All that we are saying is stating the obvious, that in considering the conspectus of the evidence, these are the issues that are already on record that must be factored into the equation. Nothing new. We putting on record what ought to be considered. I don't understand the objection by my learned friend. Nothing, no new application. We're just saying the court, as we have done, we have summarized the evidence. These are aspects that we could have mentioned in the summary of our evidence. We're just saying, in addition to the summary that we've given, these are also the aspects that must be factored into that summary. Nothing new, my lord.
Okay, is that the end of the argument?
Yes.
So what do we do?
Yes. I think Advocate Ngumalo wanted to respond to the state's submissions, and that's where we are in terms of the process. But there was that one aspect that we wanted to put in record that appears on Exhibit EE, which would form part of, which forms part of our submission as far as accused number 4 is concerned. And as I say, this is not something new. It's already on record. The proceedings of 27 October 2020, page 5, the last 2 lines, accused number 4, Your Worship, I do not see the necessity in acquiring legal assistance because we do not have money since we've been brought before court. The people who are supposed to be appearing before court are not before court because they have money. That's all that we wanted to put in the court.
Okay, fine. Yes, yes.
I mean, like, how does that like address like Baloyi, man? Come.
Is that the end of this application now?
Yes, those are our submissions, my lord.
Yes, Mr. Normal. Are you through too?
My lord, I'm not in a position to respond because in respect of the statement of Makaleni, the 7 requirements in terms of the Act have not been met. I've never heard the state discussing the issue of the nature of the proceedings, the nature of the evidence, the purpose for which the evidence is tendered, and the property value of the evidence of that statement. In fact, my lord, in my address,
Quoting the SC Act, I mean the Constitutional Court case of Darcy. You're not quoting that case, sir.
no.
Yes, the one that we quoted, my lord, it's Kappa.
Because it is the
Kappa.
yeah, it is the
Just listen to this. Just listen to this. The judge is thinking Baloyi quoted something that he's thinking about, but Baloyi didn't quote that. Baloyi used something else. I mean, he's just testifying for Baloyi, like he's giving him hints, he's giving him ideas like broad daylight, testifying from behind the bench. This is amazing. The informative channel, thank you, sir, for commenting. Let me read your first comment. The state has a struggling evidence. Struggling evidence. Just like Mr. said, they have been prosecuting other people based on flawed procedure. You're right, sir. I mean, everything that the state has been doing is just being flawed. Like, there's nothing that satisfies you to say, no, here they did their job. Like, I could take out the only person we could take our heads off to, the DNA guy. The DNA guy and Mrs. Steenkamp and the people who like wanted to honestly prosecute this case. Those are the people that we can. But these guys with cooked information, we can't place much trust and much hope on them solving this crime. No, we can't. Look at the things that they're doing. Is this the way that Baloyi has been winning cases? Just ambushing the defense like this with flawed procedure. Let me read the second comment from the informative channel. In this case, Ratha must just cleanse himself by taking the right decisions based on the criteria that is needed to discharge the 5 accused. If this case goes for an appeal, Ratha will be exposed. Yeah, at this point, I don't think he really gives a damn about his league. It's like most people don't these days. When you look at the importance of currency, the importance people placed over currency. Yeah, like people don't really care about values anymore. No, I don't think so. People just want to leave a legacy, a currency legacy for their children. That's the main motive nowadays. Let's listen some more, and I'm gonna close the live.
Constitutional court speaking there. It's not
The act speaks.
yeah.
The Constitutional Court refers to an act. So
Yeah.
when an application is made, the 7
It's a judgment
requirements.
of the Constitutional Court. What
Yes.
more do you want me to say?
Yes,
And he's reading that judgment.
yes,
And that judgment says there are 7 categories which must be satisfied.
yes, yes.
So what is the problem?
Has the state satisfied those requirements?
I don't know if I'm saying that judgment, as I understand it, that's what it says.
I understand, man. Further to that,
Mm.
in my application, I never referred to the statement of Makadene. So how does it find its way through this court in this
Yeah,
application?
fine, you can argue that if you want.
Now I want you to listen to this now. The judge is saying, Baloyi is saying this, and then you guys are saying this. But really, what I want you guys to do is put your arguments across. Your arguments, if they are wrong, I'll correct them now. But if Baloyi's arguments are wrong, it's fine. I'll just shut up and then you'll see later. But he's correcting them now. Whatever they're doing, he's correcting them now. And another example is just going to come now when he's telling Mumalos that you guys are saying there's nothing like that. There's no case like that. And I know a case. And then he quotes a wrong case again. And then he leaves it hanging. And then he quotes another case when Ramsepeli now came in, cutting him in the middle. We couldn't even hear if that case is really related to what he's talking about. Let's listen some more, and then so that we can get the whole context of how Ratha manipulates the defense.
Because my daughter, I've referred this court to the case of Mketezi to say that for the 5 requirements, they must be met for my client to say he formed common purpose with the others. But now the state is referring to the Makadeni statement, of which I never referred to Makadeni, as to how Makadeni and accused number 4 is related in respect of this application that I've
Yeah, you
dealt
can
with.
argue that I must reject that argument.
That is my argument,
Yeah,
my
fine.
daughter, that I respectfully ask the court to reject that evidence.
Yeah.
It finds no application in the application that I've made before this court on the 25th of August. That was
Okay.
on Monday. Thank you, my daughter. Thank you.
Right, so when do we reconvene?
Here's the deal.
You see,
You've been burnt, but
Just
prove
want
yourself
to-
to developers.
he just wants to cast them off.
So, may I perhaps find clarification? On Tuesday, when the issue of Makaleni reared its ugly head. Advocate Munisi stood up and inquired from the court whether, because of that, the Makaleni issue, which was not canvassed in Advocate Ngumalo's application, and it does touch on particularly Mr. Ntanzi. And further, my lord, regarding the manner in which the response by the state seeks to have the extracurricular statements of accused number 2 apply to all accused persons that are before court, which is anti the Mhlongo case. So on that basis, Mr. Advocate Munisi asked whether we will be afforded an opportunity to reply, and the court confirmed that we could reply. Hence, in the morning, I was asking, is that procedure? Because those are fundamental issues in this application, my lord. It has escaped the circumscription for the application and the reply. Now we are in Swana. We are touched by blood. That was not meant for us.
You know what? If you guys apply the law and you know the law, there won't be problems. If he knows the law and he applies it, there are no problems. If he does the same, he applies the law and does it, and he argues, and you say, I must write a judgment. I'll write a judgment because I know the law.
Yeah, because we found ourselves perplexed.
So if you want to supplement your heads, you can do it, no problem. If you think it's necessary.
Just listen to that. Just listen to tell me why does he have to say that? Did they have to say that? Like, where does them supplementing heads now, where does it feature? Like, how does it enter into this arena? Like, how does it enter into the fray? Why does he have to include them now? I mean, it's confusion. It's just to arouse confusion, because they never suggested that they want to alter their heads or amend them or anything like that. They're just perplexed at the procedure that Baloyi is using to ambush them with new evidence where it's not expected. New evidence is not expected when a 174 answer from the state is expected. Now they're coming with new evidence. The judge can't even correct that because he let it slip yesterday. He allowed Baloyi to come up with this new evidence. Now he doesn't know how to control it. He's just diverting. He's now asking them if they can amend their heads of argument. Why does he have to ask that question? Did you hear Ramsepeli saying anything about amending? Because they were just concerned that as Baloyi is bringing this, the first concern from this was Baloyi is bringing in new evidence at this juncture, and it's not allowed, and it's something that's strange. Now, are we going to allow to answer? Now, if the question is, if the answer is yes, we are going to be allowed to answer, to respond. Another question will arise. What is the procedure? What kind of procedure is this? Where new evidence is now being allowed to be introduced and we are allowed to argue over it during the application for 174. It's not even during the application for 174. It's during the time that they have to answer the state. After Ngumalo had placed his own argument on the table, now they feel like it's something, they missed something. They failed to do what Minister is suggesting. Just make a new application that, no, okay, let's put in a new application to do this and this. They don't want to do that. They just want to sneak in the information. Let's listen some more. It's just diverting their heads. Put in arguments, like amend your heads of argument. Who said they want to do that?
My lord, I stand as an officer of the court because I did not per se make an application. But if I see issues that are, I feel as an officer of the court that things are not going well, my lord, I should stand up and ventilate and assist.
I can tell you what is your problem.
Yes. What is my problem, madam?
If you read that charge sheet,
Yes.
it says the five gentlemen.
Listen, now this is where he's giving Baloyi guidance. Also, argue conspiracy. Because Baloyi is saying common purpose, right? Now he's mixing it into one with conspiracy. Just listen, because he knows he has something up his sleeve to support the conspiracy argument.
There
Listen.
are charged in terms of section, common purpose, and then it's section 51 what?
51.
Just read 51.1, because that is the problem, I can tell you now.
And 51 is not the one. You listen, you hear now. 51 is not the one. 51 is something else. Now it's going to change. It's going to try to push them towards the conspiracy thing.
Jesus.
One is more of minimum sentence.
Yeah, the conspiracy part. They not charged with conspiracy.
What we do mention in the indictment.
He's asking, are they not charged with conspiracy? But he just said they are charged with conspiracy. You see how the judge operates? Sneaky.
That are charged in terms of common purpose and or conspiracy, but
in the indictment.
Yes, in the indictment.
I think that is the problem here.
Yes.
As I understand the law, if you are charged in terms of a common purpose and a conspiracy, it applies to, according to the state, not me. It applies to everybody who's charged.
Manot 51 deals with sentence.
No, he says it's not. He says he mentions it as a conspiracy.
Yes.
Okay,
Yes.
that's how I understand it.
Because Manot, for me, the concern is this Makaleme issue.
You see how they just slipped out of that? There's no law that was quoted. He said 51 is not sentencing. Now he doesn't want to mention any law. He's just closing over that. No more attention is given to that.
The procedure that I know is that before the close of the state's case, the state, if it wishes and intends to lead or to have the court admit hearsay evidence, it stands up and makes an application to the court to say, my lord, we've let hearsay evidence, for example, of Makaleni, and we are making an application for that hearsay evidence to be admitted. And both the parties, the state argues the admission and we argue against the admission. And the court makes a ruling. Now we are stuck here where these things enter via the back door.
I only make a ruling when I deliver the judgment.
Yes.
Not before.
Yes.
Okay. I listen. Before then, I listen.
Yes.
Just listen to this, guys. I mean, this judge is not really paying attention to the arguments that defense is putting across. Ramsipil is simply telling him, like, it's just knocking down the process to a simple form. Something that was supposed to happen. If Baloyi wanted to introduce this Makaleni evidence, it's fine. What he should have done is make an application to apply for it, like to be introduced, and then they argue against it. After his application, he brings his counter argument, and then they bring their closing, and then the judge asks his clarifying questions, whatever. Then that thing is judged upon, like a judgment is given. Okay, we allow this, or it's not allowed, or it's provisionally allowed until what the judge was always saying, until this guy comes here and come and testify. Yeah, are you going to call him Mr. Baloyi? Something like that. That's what they're asking for. Listen to what the judge is saying. He's changing it. And then, his eyes tell you all. He's not with them. He's just thinking about this memorial service.
If he misquotes the law, I just listen.
Okay.
He's not
Yeah,
answering.
because that was my concern.
He's not answering the fact that why is he not telling Baloyi, are you making an application or not to allow this? He's just allowing that thing.
That the law was
So
quoted,
if you and Mr. Ngumalo say there's no law like that in South Africa, fine.
He knows a law. Rest assured, he's going to know a law that will counter them. Listen.
Yes, because
I can tell you there is a law like that. State S versus
wrong again.
roll.
Wrong again. Wrong. Another wrong ruling. He's gonna try to change it. He's gonna try to talk the story about that ruling, which just listen to this chat, man.
Wait. There's another one also where this judge, he's a very experienced judge. It's I think it's Falam. Falam was handling a case in Joburg. The state and the defense argued.
Right. At this point, I'm going to close it because it transpired to the point where Ramusipili was cut off by SABC because they didn't want to show us. I think they have the idea or they are in discussions with ENCA they know that ENCA is not showing, so they are doing all kinds of nasty tricks there, depriving us of the information there. We really need independent media, some people who broadcast these proceedings live without relying on the public broadcasters. Anyway, I'm going to close this live, but I just want you to be aware of how Ratha is bamboozling the defense. He's just skating around. He's just dancing circles around them. Like he's not giving them answers. Everything that they bring up, he's just he's just on the side. He's talking about something else on the side, not really addressing what they're talking about. The only time that I felt like in this whole argument about Makeleni, in fact, not Makeleni, I think Makeleni's evidence is going to take it. The only thing that he made sense on is that ruling that he reminded Baloyi of, that these guys, since they had not made a plea, you can't say no. You are going to use that information that they were spewing at the Boksburg Magistrate Court against them. That's where I hear him making sense. But on this one of Makeleni, he's the one who brought it up. Now he's trying to walk Baloyi through it to help him to accomplish that goal of winning this argument of allowing hearsay evidence when it was not even led. And if you really look at it proper, Ramusepilo was not even talking about Makeleni. He was not even reading Makeleni's statement. He was just asking that lady about it, Zani Kumar. He explained it today, but nobody paid attention to that. Anyway, guys, let me not take too much of the time. I'm gonna say peace. Thank you for checking me out. Those who were in the live, thank you, Mr. The Informative Channel. Thank you for those two nice and precious comments. Thank you for those who were watching. Thank you those who like the live. I'm gonna be out. Peace. We are out. Before I go, please like and subscribe. Those who are watching and not subscribing, I don't know what's the problem, but just subscribe. Just give me a subscribe. I mean, it's not that hard. I mean, people are subscribing for people just showing, just dancing, like, so give me a subscribe. Anyway, peace. Before we do that, like and subscribe, hit that notification bell so that when we drop more content like this, you are in the loop. Watch the judge. The Judge Ratha is back on his, back on his BS. Anyway, peace. We are out.